Financial and Legal Issues, Part 1.
Thank you for coming. I know Ashley said that I was from a nonprofit that serves Dakota County, but as we serve older adults and their caregivers, I have to tell you, no two older adults are the same. No two caregivers face the same issues, but there are things we can learn together and be prepared for together. So thank you for joining me in what is one of our most popular and also most intense learning opportunities for caregivers. November is National Family Caregiver Month, so let me just take a moment to say thank you. You are the first line of care for older adults. If we put together all the care given to older adults by home health aides, by nursing assistants, by home health care agencies, by assisted living facilities and nursing homes, and put that all together, family caregivers provide 3 times more hours of care than all of those put together. You are the first and foremost line of defense for those older adults. So let me start by saying thank you. I want to take just a minute to go over your handouts. If you focus on the left side of your folder, that's where we're going to be spending our time today. So you will find a brief outline of the points that we'll cover in today's presentation. You will also find the Minnesota statutory short form for power of attorney, and then also the healthcare directive form. And so those are the forms we're going to be going through today, and it'll probably be helpful for you to follow along as we go through those forms. And these are the subjects we're going to be talking about. We're going to talk about the benefits of learning this information and having this knowledge beforehand. We're going to look at some financial considerations that you as caregivers might be facing with the older adults you care for and love. We're going to talk about the legal considerations, that power of attorney. And then we're also going to be talking about long-term care. It's kind of hard to know where long-term care fits in the spectrum of presentations, but because long-term care is complicated and has legal ramifications, we put the long-term care section in here as well. So hopefully we'll give you some information that will bring clarity to the whole conversation on long-term care. There are 2 benefits, I hope, to you for being with me today at this presentation. The first one is that you'll hopefully have more information so you can better care for the older adults in your life. But then I'd like to think you're also going to learn some things that might help you prepare for your aging journey. I think that's the last great gift the greatest generation is giving us, is they're giving us an opportunity to watch them age with grace and follow their aging journey, and then make decisions about how we want our aging journey as well. So in our presentation today, we'll talk about some of those legal and financial things that you can look forward to. And you know, maybe you want to say, let's go through this together. I'll do my advance directive, Mom, while you do your advance directive. I'm going to start thinking about my power of attorney, Mom, while I help you figure out your power of attorney. I invite your questions at any time, understanding that they are often interrelated. A question about power of attorney may get actually answered in advance directive. But let's walk through this together, okay? All right, so let's first of all talk about the benefits of planning. The day came for me, as it may have for many of you, when a doctor called us into a consultation room and gave us some news for which we were totally unprepared. And I kept saying, for 2 years after that, I kept saying, if anybody had ever told me that I needed to know this stuff, I'd have found the time. I'd have found a way to learn this stuff. But I never knew I needed to know it. So that's the benefit of planning, is what you are doing here is hopefully before you're in crisis, and hopefully can better avert the crisis. If we can take care of the things we can plan for, then we'll maybe have more time and more energy for those things that are going to come at us that we weren't expecting and that we can't plan for. So we want to avoid whatever crisis we can. We want to develop a plan, and that's what we'll work through this morning. And then we'll avoid, hopefully, that crisis management that doesn't bring out the best in any of us when we're managing in crisis. So, managing the unexpected. If you take a look at your parents' life, how are bills paid currently? How are health care decisions made? And how do you know that as those decisions are being made by someone other than the older adult involved, how do you know that you're following their wishes? A very good reason to do this kind of advanced planning, so you have that level of assurance. So we're going to start with financial considerations. That's kind of clear, it's kind of simple, we'll kind of walk our way through, and then it'll kind of help us dip our toes into the legal and the healthcare decisions that are coming up next. We're going to talk about power of attorney. We're going to talk about what's the difference between a guardianship and a conservatorship. I realize that since I'm talking to employees at the Department of Human Services, you could maybe help me teach that part, but I'll try and keep it. I'll try and keep it informative. Oops. And then we're also going to talk about those health care directives. So, what is a power of attorney? And maybe you want to get out the Minnesota statutory short form power of attorney so you can follow along with me as I do this. What is a power of attorney? It gives legally delegated authority as you would an attorney. So if you think of it as in you are giving the power to someone to act as your attorney, to make financial decisions for you, to make legal decisions for you. You know, something's not quite right, so I'm going to back up. I think I missed a slide in my PowerPoint. Sorry, Julie. But I'm going to go back over here and do it manually. See? Did we see that slide? No. All right. See how we went right from, I said we were going to talk about financial issues, and then we went right to power of attorney, and just like that I knew I had missed something. So this is the three different ways you can set up, make financial arrangements for your parents. How many of you have a joint banking account now? With your parents or with a spouse? Okay, excellent. So a joint account for your parents can be set up just like a joint account for a spouse. So on this graph, you will see the three different kinds of accounts, and then who has what authority? Who has authority to withdraw or make deposits? Who actually has ownership of this account? And then what might be the risks involved with the account? So the joint account is just like we have with our spouses now, or some of you have with your parents. So it is literally joint ownership. I have as much legal claim to the money in that account as my elder does. I can make withdrawals, I can sign checks, I can make deposits. Upon my elder's death, because that money is as much mine as it is theirs, that money becomes mine, which can be handy. There are going to be funeral expenses you want to pay for, ongoing bills that are coming in regularly. You can get all of that taken care of out of that joint account. The risk with a joint account is, what if the person you have the account in joint with abuses the account? What if they take the money? Remember where I said it's as much my money as it is my father's money? So if I wanted to go to Las Vegas, I've never been there. Who knew I might want to go? I could just as easily write out the check out of that account as out of my own account. So there has to be a level of trust, a level of mutual understanding. Joint accounts now in the days of online banking are excellent. Caregivers can make excellent decisions. You go visit Dad and Dad says, yeah, I want to get some new shoes and it's time I got some boots because the winter is coming on, and you just checked before you came over and there's only $27 in his checking account. Then you can say, Dad, that's great. Can I transfer some money out of savings to do that? Or do we maybe want to wait a couple of weeks until some more checks come in? And you can do a better job of helping them with their finances. So that's the joint checking account. Any questions on that? Yes.
I have a question. With joint account, you don't have to sign off on every check. So let's
Nope.
say mom and dad wanted to make some purchases. I don't have to
Correct.
sign off.
Correct. Not at all. Right, exactly. Both of them have equal ownership of the money. Yes, ma'am.
Does restrict mean?
Oh, good question. So I've now gone to Las Vegas and taken $3,000 worth of Dad's money to go to Las Vegas, and he's getting smart and saying, uh-oh, I no longer want Colleen on that joint account. He can't take my name off that account. That's as much my money as his. Now, he can withdraw the rest of the money out of the account, close the account, and open a new account. He can certainly do that. But he cannot remove my name off of that account. Again, it works very well. It's a good tool. There are some risks associated with that account. The next one is an authorized signer.
I have another question.
Oh, yes.
On the second point where it says creditors can tie it up, what does
Oh,
that mean?
gee, you guys are good. Thank you very much. So I've gone to Vegas and I've lost big time. And now creditors are coming after me because I'm not paying my bills and I'm not paying my credit cards. And my name is on this joint account. I am not doing my dad any favors, am I? Because now since that's my money as well as it's his, they can take the money out of that account for my bad debt. There has to be a level of trust or checks and balances in this in order to make it work for everyone involved. All right, so another opportunity, yes,
How many people can you have on a joint account?
as many as you want.
So if you have like 6 brothers or sisters or something like that, and they want them all on there, you can do that?
They certainly can. And then, I mean, I can't imagine one reason why that would be a wise decision, but it's their money. And if that's the way they wanted to deal with their money, that's scary, but it's their choice. All right, so an authorized signer is simply someone who can sign checks, can make withdrawals, but that's all they can do. They do not own that account. That account stays in the elder's name. Upon their death, that account automatically goes to the estate. Once that person dies, once the elder dies, then the person who is the authorized signer no longer has any legal standing or any claim to that money whatsoever. That money becomes part of the estate, and now the executor of the estate has control of that money. So again, you have the same potential for abuse by the co-owner. It just simply assures what happens upon the elder's death. And then the last one is the payable on death account. And your elder can set up an account that simply says, this is my account. I'm the only one who can write checks off of this account. All of the money in this account is my account, except on my death. Then it belongs to Ashley. Ashley, my father trusts you now more than he trusts me, so he's going to let you have the money.
Then that becomes not restricted by probate.
Correct. So the person who's named has no access to the funds while the older adult lives. And then once that older adult passes away, then they have control over that money. The downside is there's no guarantee that they're going to say, father might have said, I want all of this money to pass to, could I ask your name?
Mary?
Mary? And Mary, upon my death, then I want you to split it between the 6 of you. Congratulations, I'm glad that's what you want, Dad, but Mary can now join me in Las Vegas if she'd like. Because there is no legal obligation. Upon his death, it becomes Mary's money, and there's no legal obligation for her to follow any wishes. If he had wishes that he wanted to ensure were going to be followed, then you would need to use a will or another method of assuring that.
Can you put multiple people on that so that it does get divided? you want?
Yes, absolutely. You can put multiple people's names on that. All right.
Make a will and appoint an executor.
Absolutely. Absolutely. I'm not sure Julie caught that. So what she said was you can always make a will and appoint an executor. And that is one way to make sure that your wishes are followed through both financially and with the rest of your estate. But in the short term, you know, older adults some of them don't want to deal with that. They don't want, A, to be to burden you with the fact that they may need those considerations, and they also don't want to think about it. They're watching friends going through some tough times, and that's kind of draining, and so they really don't want to think about the day when that might happen to themselves. And so that's why I suggested that you partner with them on this. You know what? I'm going to think through how I want this to work for me while you think through how it works for you, because I think this is a good idea. And that's just kind of a good way to help broach the subject with them. All right. Any more questions on banking accounts? And then we'll move on to the power of attorney. Yes, I'm sorry. You had a question?
If you have a joint account, can you switch it to a payable on death account?
The question was, if you have a joint account, can you switch it to a payable on death account? Assuming all the names on the joint account want that to happen. But if the person who's the designee doesn't want that to happen, then let's go back to close that account, open a new account, and set that up as a payable on death. All right? All right, so now let's move on to power of attorney. So you might have heard this just recently. So this is giving someone the kind of authority you would give an attorney to make real estate transactions on your behalf, to make financial decisions on your behalf, to give away what you own to someone else, to purchase things for you that you maybe didn't have a say in making. A power of attorney is legally giving someone that power on your behalf. How many of you have heard about the phrase durable power of attorney? Be sure you get a durable power of attorney. Does anybody know the difference between a power of attorney and a durable power of attorney? Yes?
Power of attorney is done at their death. Durable allows you to act after their death.
Not.
Really?
Power of attorney under any circumstances ends when they die. Because when I die, I no longer need an attorney, and all the powers granted in a power of attorney document end upon the death of that person who has given away that power. The difference between a power of attorney and a durable power of attorney is a durable power of attorney is still legal even if that person is no longer competent to make decisions on their own behalf. So if my father makes me his power of attorney and then he has a stroke that affects his brain, and I go in to visit him and he never again for the rest of his life knows who I am, a durable power of attorney will mean that I can continue to make decisions for him because that's what he said, even if he no longer knows who I am. That's the durable power of attorney. All right, so let's walk through this power of attorney form and just kind of go through what powers it has and what it doesn't. One more thing I want to say. If you are caring for a loved one in Hudson or in Fargo or in Sioux Falls, please know that this power of attorney form is state specific. So you now know what it's called, statutory short form power of attorney, South Dakota or Wisconsin. So whatever state your elder is in, you need to get the form filled out for that state. They're all pretty much the same. They're very much standardized, but this one isn't any good in Hudson, Wisconsin. Yes?
So if they travel a lot, they winter in Florida, then maybe you need to have a Florida one too?
They have a place of permanent residence, the place where they...
But if they die in Florida while they're vacationing, but they really live in Minnesota?
You know what? It's not going to hurt anything to have two. And we'll walk through this. I'll go through this one step at a time. So as you look at this form, the very first thing you need to fill out is the name of the principal, and that is the elder, the person whose rights we are about to be talking about and whose properties and assets we are talking about. Excuse me, gets filled in here. And then the attorneys in fact are you, the caregivers, however they want to have that done. So they can say that Mary or any of her 5 siblings can be authorized to make decisions granted on this. They can say Mary and her 5 siblings. So Mary and all of her brothers and sisters need to make all of the decisions in joint. Again, I'm not sure why they would, but certainly there are families where they have 2 children, and that might make some sense. Or they can fill out a separate power of attorney for each child. So they might want to give, if you turn to page 2, you will see the authority that can be given out. So they may want to give their oldest child the right to make personal property decisions, and child number 2 the right to make bond, share, and commodity transactions, and child number 3 gets to do the insurance, and child number 4 gets to do, they can do a separate power of attorney for each of those rights if they so choose. Or, more often than not, they will choose N, all of the powers listed above, A through M, and give that to one person or 2 siblings that can function in joint. Okay, that was a whole lot of they can do this, they can do this, they can do this. Do you have questions for me on that? Yes. They are wrong. They are wrong, but as long as, I mean, you've got work to do. Yeah. And if that's an expedient way to get it done, but they aren't. As one of my sisters would say, they are not as right as they think they are. All right. So, and then the last thing they can do. Oh, I wanted to point out that down here. All right. So down where it says second, towards the bottom of the second page, where it says second, you must decide and indicate below whether this power of attorney shall continue to be effective if I become incapacitated or incompetent, or this power of attorney shall not be effective if I become incapacitated or incompetent. That's the difference between a power of attorney and a durable power of attorney, even though it doesn't say that on here anywhere. And so checking that, I would think we would all be more comfortable if they granted us that, even if they became incompetent. But that's where the difference between a power of attorney and a durable power of attorney. And then fourth, the last one, which is at the top of page 3, just says that the older adult can, especially in a case like maybe perhaps Mary's, where there are 5 other siblings, only one's going to get the power of attorney, and the other 5 are nervous. Abuse happens. Nobody expects to be financially abused, but it happens. So mom and dad can say, but Mary, quarterly, could you give a report? Could you just show the family how you've been handling those transactions? And that's where they would request that. This needs to then be signed and notarized, and as you will often find, everyone wants an original. So you might want to make 4 or 5 copies and have them all signed and notarized. The older adult needs to be present, needs to sign. The person to whom they're granting the power does not need to be present, does not need to sign or be notarized. And then one last word on power of attorney. It's nice to check in on them every 5 years and make sure that they still make sense. My mother-in-law lives in the Chicago area. She had 1 son in Milwaukee and 1 son in Hastings, Minnesota. It was a no-brainer 10 years ago, 12 years ago, when she created her power of attorney. And when asked, do you have, yep, got that covered, yep. Well, she's now 83. And her son, who used to live in Milwaukee, now lives in Juneau, Alaska with his wife and 10-year-old twin daughters. And anyway, so it took a while. We had to, but who thought? You know, yes, we all knew she had the power of attorney and the healthcare directive filled out. Doesn't that feel good? Wouldn't we all be more comfortable? It's just that, dang, life has changed all around us and we didn't even notice it. And so now we need to go back and do some backtracking. All right, any questions on the power of attorney? Oh, good point. A power of attorney is difficult to revoke, but it can be done. It can be done by going around to all of the places where you've given a power of attorney and tearing them up and then providing them with a new power of attorney. So it's kind of cumbersome because now we're dealing with elders who over time are becoming more frail, who are getting around and doing all of that work might become more and more difficult. But it can be done. Yes?
As far as backtracking, so how hard is it to change the power of attorney? I mean,
You need to go back and once it's been signed and notarized, it is a legally binding document. So to revoke it, you need to go back to every place that you've now given it to and rip it up and provide them with a new one. Or there is a form that can be filled out for revoking a power of attorney, but I can't imagine revoking a power of attorney without wanting to instate a new one. So it's easier to just go collect it and hand them the new one.
So maybe what one needs to do is create a spreadsheet or something like that to state the number that you've made and whom you've handed them out.
Absolutely. That would make good sense
And
to
maybe
somewhere
put a
have a
number
list.
somewhere on the bottom, 1A, 1B.
Good point. Then you're sure you, yes, Mary?